Clydebank Engineering Company vs. Castaneda 1904. The House considered a contract for the construction by a Scottish shipbuilder of 4 torpedo boats for the Spanish government. The contract provided that the penalty for late delivery shall be at the rate of £500 per week for each vessel. Although described as a penalty, the sum in question was to be regarded as liquidated damages and therefore recoverable. Lord Halsbury considered that the basis for interference by the courts in an agreement between the parties was whether the clause was unconscionable and extravagant. It was obvious on the face of the contract that the very thing intended to be provided against by this pactional amount of damages is to avoid the kind of minute and somewhat difficult and complex system of examination that would be necessary if you were to attempt to prove the damage. Lord Davy applied a principle of interpretation of contracts in Scottish law. My lords, I therefore conceive that it may be taken as an established principle in the law of Scotland that, if you find a sum of money made payable for the breach, not of an agreement generally which might result in either a trifling or a serious breach, but a breach of one particular stipulation in an agreement, and when you find that the sum payable is proportioned to the amount, if I may so call it, or the rate of the non-performance of the agreement, for instance, if you find that it is so much per acre for ground which has been spoilt by mining operations, or if you find, as in the present case, that it is so much per week during the whole time for which the non-delivery of vessels beyond the contract time is delayed, then you infer that prim facie the parties intended the amount to be liquidate damages and not penalty. I say prim facie because it is always open to the parties to show that the amount named in the clause is so exorbitant and extravagant that it could not possibly have been regarded as damages for any possible breach which was in the contemplation of the parties, and that is a reason for holding it to be a penalty and not liquidated damages, notwithstanding the considerations to which I have alluded. Evidence as to the loss which the Spanish government had actually suffered was inadmissible.